Hey everyone, Scott Rattigan here with functionallawyer.com. And today we're talking about one of the most important things you can do to protect yourself from malpractice suits or from regulatory discipline and any actions against your license. So I'm talking, of course, about having a strong informed consent process in your business. And we're going to go over what it is, why it's so important. I mentioned a couple of reasons why earlier, and then how to actually execute it properly, right? So what is it? So as the name suggests, and most people should know, is that it's the process of informing a patient about the treatment plan or the specific modality that's going to occur, and before you execute that plan or modality, and then getting the patient to consent to that plan, right? And so it sounds very simple, but you just kind of explain, and it is really, but you explain what's going to happen, but you also have to explain the risks of the treatment, the benefits of the treatment, the expected benefits, and then any alternatives to the treatment. So typically you see this used a lot in surgery. So someone goes in for surgery and the doctor has a conversation with them and says, yeah, we'd like to remove your knee and we're going to put in a new one. Here are the risks. There could be blood clots. There could be any number of risks with surgery, especially if you're undergoing any kind of anesthesia. Great. What are the benefits? Well, you may not have knee pain for a while once you recover from the surgery. And then what are the alternatives? Well, you could put it off for a while. You could do some vascular therapy in the hopes that the knee gets better. You could replace some ligaments, but that's kind of just an example here. So the risks, the benefits, and the alternatives to either the specific treatment or the overall plan. And so why is it so important? Well, in any business, you really want to have everything kind of laid out for your clients. Like no business wants unhappy clients. So you want to kind of have that conversation with them and explain all of this so that they go in with a clear mind. Just on the off chance that anything happened, they knew what was going to happen. They knew that there was a risk of it, right? And secondly, there's an ethical obligation oftentimes for licensed providers to actually do this, have this process in place, if not a moral one, right? You want to tell people what's going to happen to their body before it happens, or what could possibly go wrong, or you obviously always talk about the benefits, but talking about the risks is important as well, even if they're minimal or very unlikely. And then the final thing is, as I mentioned earlier, it's a good starting point to a defense for malpractice suits and any kind of regulatory action that a medical board might take against you and your license. So how to do it, right? How do you do it correctly? Well, the first thing is that we see sometimes is people just stick the informed consent document in the intake paperwork, and it's under a stack, and it's under the notice of privacy practices and the patient health history questionnaire. And that's actually not the best way to do it. Some judges, or at worst juries, might see that and say, well, that's not truly informed consent because I've signed a stack of legal documents and I never read them, right? I just read it and, where do I sign? And I sign it, great. So a judge or a jury can just toss that and say it's not truly informed consent and it's not valid. So what you want to do first is have the conversation with the patient. And when I say conversation, that's two ways, right? So you don't want to just kind of lecture at the person, okay, here's all the risks, here's all the benefits, here's the alternatives. You okay with that, right? Right, yeah, you don't want that. That's sometimes called a leading question. You definitely want to give the patient the opportunity to ask questions, to fully understand in terms, on their comprehension level. If in the case of a child or someone with kind of a cognitive decline, you just want to make sure that they or their legal representative are aware of everything that's about to happen, and they're okay with the risks that are involved. And then once you have that conversation, then you give them the document, the memorialization or documentation of that conversation. So the document should say something like, yes, name I, patient, do consent to this treatment, functional medicine, acupuncture, whatever it is. I am fully apprised of all the risks and the benefits. Some of the risks are, and you list them out. Some of the benefits are, you list them out. And then I know I'm aware of my alternatives. It could be just putting this off or going to a conventional doctor. And, and I'm okay with all of that, right? And I agree, I consent. And so It's very important that you do this correctly, that you do the conversation first. It's a two-way conversation, and the documentation comes last, after the conversation, not before. So there you have it. Those are the best way to execute an informed consent process, a strong one, to protect yourself from malpractice and any regulatory action against your license. So if you don't have one in place, I suggest you get one already, the process. And if you need one of the documents, one of the forms, we have an informed consent at functionallawyer.com. It's there for you to download. You can get it, or you can contact me at functionallawyer.com. That's the name of the company. All right, until next time, see ya.